Hello, welcome to Workplace Wake Up. I'm Jen Shaw. Every week, I spend about 15 minutes covering key legal developments, introducing you to interesting guests, and providing some entertainment to start your workday. I hope you enjoyed this week's episode. Hello, everybody. Thank you for joining us on the podcast today. I'm so happy to have you here. Oh my gosh. So in a little bit, we're going to be doing our wage hour audit webinar. So I think some of you are probably going to be joining us on that. We're going to have a lot of fun. I love doing our webinars and seeing all of you live. I wish I got to see you live on podcasts. Maybe I'm going to have to think about how to do that. Anyway, today we're going to talk about leaves of absence and reasonable accommodations. Why, you ask? Because last week when we did the podcast on wage hour audits, it dawned on me, well, sure, you want to audit wage hour issues, but we do audits on HR practices, right? And leaves of absence and reasonable accommodations are two areas that we find a lot of non-compliance. We find folks who are doing things they shouldn't be doing, not giving notices they're supposed to be giving, writing things in their letters like, "Dear Matilda, we can't wait for you to come back to work. Remember, you must be 100% able to do your job. Please let us know if that will not be possible. Love, the employer." Well, that doesn't work. Matilda doesn't have to be able to do 100% of her job if she can be reasonably accommodated. All right, so we see boo-boos in this area all the time. Now, I had a really fun experience a couple of weeks ago. One of our clients that's a transportation agency in the Bay Area, they came up, two of their leaders came up, and we had sort of a working group on leaves of absence and accommodations. And it was so much fun because we went through sort of the basic laws and all of that, which they already know. And then we looked at their template letters that they send and their policies and their collective bargaining agreement and their MOUs. And we came up with an action plan of what they need to do to get their house in order when it comes to leave of absence and reasonable accommodations. And it was so helpful for me to learn about the organization and where their potential vulnerabilities are. And both of the folks who came said they found it really so helpful to be able to get out of the office, come to our office, sit down and go through what they're doing in terms of leaves of absence and accommodations. And all of those things put together really made me think, I want you to do that. I know you're busy. I get it. I know you have a lot of things on your list. Maybe this will be a Q3 task. But seriously, you guys, this year, take a look at your leave policies. Take a look at your leave practices. What are you doing on reasonable accommodations, both for religion and for medical issues? How are you dealing with it? What's your paper trail? How long do you keep your documents? How do you communicate? Remember that when we're dealing with leaves of absence and accommodations, interactive process is critical. Are you talking to your employees? Are you giving them clear guidance about what your expectations are? Are you being consistent and fair in how you're holding people accountable? What you're doing in terms of, for example, prorated bonuses. Somebody's been out for 3 months. How do you calculate the prorated bonus properly? I've had a number of client calls on that issue recently because a lot of you are now calculating your 2024 bonus payments and you're trying to figure out what to do with people who've been on a leave or who have an accommodation that reduces their regular workload. So all of these issues need to be dealt with. Now, what I want you to think about is a strategy for how you're going to get this done. So even something as simple as sitting down and writing out a work plan, right? First, I'm going to contact the union if you're a union employer. I'm going to then review our policies and procedures. I'm going to decide what my philosophy is going to be on a certain topic, such as, am I going to allow benefit continuation beyond what is required by the law? How am I going to designate FMLA, Family and Medical Leave Act, and California Family Rights Act leave? What paperwork am I going to generate? Where am I going to store the paperwork? Why or should I require employees to send those doctor's notes to HR and not to their managers and supervisors? How do we keep private the information that comes in, whether it's medical or religious related? How do we make sure employees can feel comfortable giving us that information that we're going to be treating it appropriately and that it will not be shared with people who do not need to know about it. So I want you to think of leaves of absence and reasonable accommodations the way we think of wage hour. It's a recipe, right? My daughter does a lot, Ella, of cooking and baking. And we were talking the other day, and I've used this analogy before, and I think it's really helpful. We were talking the other day about the difference between baking when she's making our sourdough bread. Our favorite friend, Terry Trolio, she's a amazing person here in Sacramento. She does cranial facial work. She's just amazing. For Ella's last birthday, she gave Ella some sourdough starter. And the sourdough starter's name is Stella. She's come from a friend of Terry's, actually. So we have Stella, and when Ella feeds Stella and makes the bread, it's pretty precise in terms of what we do. When she makes cupcakes, she made her birthday cake. She's very precise about all of this. But when it comes to making dinner, like we did last night, stir fry, rice, chicken, we sort of just cut a bunch of stuff up, right? We had some bell peppers and some mushrooms and some those little corn things. I don't know what you call them, the little miniature corn stalks. And some garlic and some ginger and some soy sauce. We just threw it all together. Okay. HR compliance is baking. It is not cooking. Okay. Cooking is when you open the refrigerator and you throw everything in the wok, right? Baking is a level teaspoon of baking soda, 3 level tablespoons of yeast, must be self-rising, must be this, must be that. I want you to think of everything you do in HR as needing to be precise, using precision, making sure that everything you're doing has a reason, has a process, has a procedure, has a methodology. When you do that, you will be much more compliant with applicable laws. You will catch where you have inconsistencies. You will make sure your employees are being treated fairly. And that is really what it is all about. Okay, that's what you need to be doing when you're talking about how to ensure that you're doing everything possible to stay out of court. Our law firm, that is all we do these days. Many of you know I quit litigating in 2016. I never wanted to look at another discovery response or file another motion for summary judgment or have another judge let a plaintiff's lawyer just do whatever they wanted and not hold them accountable to deadlines and court practices. I was just done. I just wanted to focus on employers and how they can stay out of court. So that's what we do, right? We review policies and procedures, and we do audits, and we have meetings, and we have calls, and we train, and we do investigations. We do everything but litigate. That's what I want for you. I want you to stay out of court. I want you to not have to deal with litigation counsel and insurance companies and mediators and paying settlements and having your organization really dragged through the mud, which is what happens during a lot of litigation. So the way you do that is your house has to be in order. And if you're listening to this podcast, chances are you've got some power in your organization, whether you are an HR professional or you are in-house counsel or you are an owner of a company. You've got the power to make some changes. You've got the power to go through and look at what you're doing and make sure that it's being done appropriately and consistent with the law and consistent with your policies. Remember, we all love to put in our employee handbooks that the handbook is not a contract, but you know what, folks, that's exactly what it is. You're telling employees what you're doing. So when you look at leaves of absence and accommodations, and you have a policy in your handbook that says you're able to coordinate your use of paid leave with whatever wage replacement benefits you may get from the government, then you have to let people do that, right? So even if the law doesn't require it, if you say in a policy or procedure that an employee can do that, then you've got to let them do that, right? So the reason leaves of absence and accommodations are so tricky and can result in such significant liability is because they're very personal, right? Most of the time when somebody asks you for a leave of absence, it's because something's going on in their life. Now, sometimes it's a happy thing. They're having a baby, or they're adopting a baby, or they're getting married, and so they need some time off. But many times it's not a happy thing. They're sick. A family member is sick. Somebody has passed away. And so they need time off for those reasons, whether it's bereavement leave or reproductive loss leave or whatever it may be, family and medical leave, right? So when somebody asks for an accommodation, it's usually because they're saying, look, my medical condition won't allow me to do this, or I can't perform that task because it's inconsistent with my religious beliefs, a very closely held, strongly, fiercely protected belief. So you're dealing with a lot of emotions when you're dealing with leaves of absence and reasonable accommodations. And when you recognize that, when you understand that that's what you're dealing with, you know the need to be right, the need to be clear, the need to be unambiguous, the need to help the employee walk through whatever process you are imposing on them. By the way, do I have a problem with imposing processes? Heck no. You got to have a procedure and process for everything related to leaves of absence and reasonable accommodations. But remember what I always say, you're going to treat these employees like they're your favorite employee. They may be, by the way, and they may not. It doesn't matter. That's how you're going to treat them. You're going to treat them as if you would do anything possible to help them. Think about who is your favorite employee if it's not the person who you're thinking about and having to evaluate for a leave or for an accommodation. What would you do for that favorite employee? Well, that's what you're going to do for this employee. So if you can change your thoughts a little bit about leaves of absence and accommodations, which many of us feel are really complicated and complex, and they take a lot of time and energy, and people aren't always happy, and there's a lot of dispute and a lot of drama, just look at it differently. Hey, this person needs something from me. This employee needs something, and I'm going to see what I can do. I may not be able to give them what they want, but that's okay. I'll do what I can. I'll take the action I can to try to help them get what they need. When you do that, there will be more latitude for a mistake. Employees will forgive an error you make on, for example, something as important as canceling their insurance when you shouldn't have done that. We just had a call on that this morning. I told the employer, you call that person back, you apologize profusely, you tell them you've reached out to your broker, and you will get it resolved today. You are extremely sorry for any stress that has been caused, and you appreciate their understanding and their empathy for the fact that your HR department is busy. You are trying to do too many things with too few people. You're doing the very best you can. But falling on your sword is important. Being able to say you made a mistake. You didn't read a document closely enough. You didn't understand what the employee's healthcare provider wanted, and you chose to interpret it in a way that was negative, that actually did not give the employee what they needed. Okay? So when we're thinking about compliance with leaves of absence and reasonable accommodations, of course, you have to know the law. You have to know how the law works and what the requirements are, and that requires you to stay on top of things, right? We have a leave of absence workshop. Our 2-day workshop is coming up in September, in the fall, and we have limited places for that, but it's an advanced session. You don't have to have taken the first one, but if you do, it'll help. But the idea is you've got to stay on top of the law. You've got to make sure that you know what is changing and what the requirements are. And it's really helpful to get everybody together the way we do and talk about, okay, how would you handle it? What changes would you make? So if you need some help in this area, definitely join one of those workshops. They're extremely helpful and very hands-on. People just really love them. In the meantime, though, get this on your list of things to do. Okay, like I said, maybe it's going to happen in Q3. Maybe it's going to happen in Q4. But let's get it done. Let's get it on our list. Let's look at our policies, our procedures, our practices, our communications to employees and to each other, and let's make sure we're doing this right. We owe it to our applicants and employees. We owe it to ourselves to make sure we're not writing checks we shouldn't be writing. All right, everyone, before we go, I just want to remind you about the 2025 California Legislative and HR Leadership Summit. This is a first-time partnership between the Sacramento Area Human Resources Association and CalSHRM. It's going to take place from April 23rd to April 25th at the Sheridan Grand in Sacramento. You're going to get all of your SHRM credit, and yours truly will be speaking on April 23rd at 3:30. That is my birthday, my 59th birthday. I can't believe it. I will be speaking on the Pregnant Workers Fairness Act. Now, some of you may have read that the federal government is looking at making changes in that area. They are, but it is not going away. So make sure you join us for that workshop. It's going to be amazing. Everyone, thank you so much for taking your time today and for supporting us. If you've got ideas, if you want to be a guest on the podcast, reach out. We'd love to have you. Everyone, thank you so much for your hard work and your dedication to the workplace. Have a great rest of the day, and I'll see you next time. Workplace Wake Up, including our guests and hosts, do not provide legal advice in this podcast. Do not act upon any of the information discussed in this podcast without first consulting a licensed attorney in your jurisdiction. If you enjoyed this episode and would like to spread the word, please share it with others. Post about it on social media and/or rate and review it. You can also follow us on LinkedIn, Twitter, and Facebook, and email us at info@shawlawgroup.com.